Hi, welcome to the second episode of the Utsav Mukherjee Intellectual Property and Technology Law Show. For those of you who are watching my show for the first time, this show is about exciting new developments in intellectual property and technology law in India and around the world. I am an IP and tech lawyer myself, affiliated with a law firm in New Delhi. And as I have said earlier, the purpose of this show is to spread awareness on IP and tech law developments in India. Any views or opinions expressed by me in this video series are mine alone and do not represent those of any other person or entity. So, last week's episode was about the new regulations pertaining to social media influencers. Now, since they say one should strike while the iron is hot, I mostly cover topics which are essentially very relevant to the market at the present moment. So, today I'm going to talk about something which is really being spoken about and written about and debated a lot. I'm going to talk about ChatGPT and the potential IP and technology law concerns which may arise due to its usage. So, what is ChatGPT essentially? ChatGPT is a chatbot which has been developed by OpenAI, an American AI research laboratory. It has been launched very recently in November 2022, and this fancy new bot has already sent ripples across industries due to the vast array of functions that it can perform. Now, these functions include writing code, composing emails, answering questions, engaging in conversation, and even writing bedtime stories. So, there is a lot of frenzy in the digital and social media about potential job losses in the market that could arise due to using ChatGPT. But this isn't the only concern. As a lawyer, I think there's a lot of legal issues which may arise due to the usage of ChatGPT. So, in order to understand these potential legal concerns that revolve around ChatGPT, we must first understand how ChatGPT works. The new Chat AI called ChatGPT works by combining large amounts of data with fast processing and algorithms. Another key feature that it possesses is automatic learning from data patterns. Unlike a conventional search engine, ChatGPT doesn't merely show the results available by browsing the web. It in fact uses gallons of data in its possession to create and present content in response to a wide variety of requests. So that's enough about ChatGPT and its technicalities. Now let's understand the legal issues, right? So first of all, ChatGPT, whether or not it is an intermediary, is one of the first questions that arises for any technology lawyer, right? And this is not only ChatGPT. Whenever we talk about any social media app or any other form of AI, lawyers always ponder about whether the said application is an intermediary. So, what is an intermediary? The term intermediary is defined under the Information Technology or IT Act as an entity that receives, stores, or transmits electronic records on behalf of another person. Some common examples of an intermediary would be search engines, online payment sites, e commerce entities, and the like. In very simple terms, an intermediary is a middleman. It is a platform over which information or content is exchanged. Now, an intermediary is exempted from liability for the content that is created and hosted on its platform. There are certain circumstances which are laid down in Section 79 of the IT Act, which lay down essentially when an intermediary can avoid liability. So, an intermediary can avoid liability if its role is limited to providing access to a communication system over which information is made available by third parties. Essentially, this means a platform over which information is merely exchanged and not when the intermediary itself generates or creates the content that is put on the platform. So, as far as ChatGPT is concerned, it itself creates the content, right? It creates answers or output upon receiving input from users. And even the terms of use of ChatGPT make this very clear. So, it does not really meet the criteria needed to avoid liability as an intermediary, and thus ChatGPT can be held liable for violation of laws, including those pertaining to IP. So, let us now talk about the one area where there's the greatest likelihood of legal liability for ChatGPT, something which is on the mind for a lot of lawyers: copyright. In India, Section 13(1) of the Copyright Act grants protection to copyright in original literary, dramatic, musical, and artistic works, cinematographic works, and even sound recordings. So, ChatGPT produces literary work or work which is covered by the Copyright Act, right? Now, since ChatGPT creates content by using data that has been fed to it, many wonder whether it is infringing upon the copyright of other persons. Since it's taking so much data available out there on the web, combining it, putting it together, it is basically taking other people's work to make its own similar or sometimes even copied work. And Section 51 of the Copyright Act stipulates what constitutes copyright infringement. The section says that a person can be held liable for doing anything without a license, which can only be done by a copyright owner. It also says that a person is liable for copyright infringement where they provide a place for communication of the infringing work to the public. Now, ChatGPT can be held liable under the section for copyright infringement. This is because the answers that ChatGPT generates are on the basis of data that is collected from the web. It copies other person's data without any license or copyright and uses it to create answers. So it can thus be accused of copyright infringement. Now, as far as ChatGPT's own terms of use are concerned, they say that the input or request made to ChatGPT by a user is owned by the user itself. The terms also say that OpenAI assigns its right, title, and interest in the output or answer generated in response to the input to the user. So the terms clarify that output generated may not be unique for each user and that the same output may be given to separate users. However, there is no question that the output generated by ChatGPT is derived from pre existing data. So, in the alternate, one may even argue that ChatGPT is only producing a derivative work. Now, what is a derivative work? A derivative work, also known as a secondary work, is work derived from pre existing or prior existing work. No separate license or copyright is required to be obtained from the author of the work from which the derivative work is derived under the copyright law in India. So the copyright of a derivative work vests in its own author and not the prior existing work's author. So the Supreme Court of India has discussed the concept of derivative work in great detail in the Eastern Book Company case, a landmark case which any IP enthusiast or IP lawyer who is watching this would definitely know about. Law on the issue is fairly well settled by the said judgment. The judgment lays down certain criteria which a work must meet in order to be classified as a derivative work. It says that the new derived work must be somewhat different in character from the original work. Some degree of creativity must be employed to make such a work. Even if the creativity is not strikingly apparent, it should be sufficient to give a new flavor to the derived work. In order to claim copyright in a derivative work, the author must exercise skill and judgment and not merely labor or capital. Now, later, the Delhi High Court relied upon this Eastern Book Company judgment in another case called the Reykjavik versus Adwin case and held that an author would not be entitled to copyright in a derivative work merely because efforts have been made to create it. Application of intellect would be essential for copyright to vest, as per the High Court. So, this is where the catch rises. The crux of the entire issue is whether intellect can possibly be applied by ChatGPT. The Oxford Dictionary defines intellect as the faculty of reasoning and objective understanding, especially with regard to abstract matters. Now, the word abstract is of great relevance here. ChatGPT has a fantastic set of abilities. It can create great content. Nevertheless, it cannot think in the abstract. Hence, one may find it difficult to agree with the proposition that it actually possesses intellect. And the legal position in foreign jurisdictions is also something which we must look at. So, foreign jurisdictions restrict copywriting of work to in cases where the work is machine generated with little or no human control. They say that this is because original work under the copyright law in the EU is one which adequately expresses the personality and creative choices of the author. So the originality of ChatGPT's output would really be highly questionable under such a law. This is because the said output is generated by capabilities of machine learning and with minimal human intellect involved, right? In ChatGPT's case. Now, there are even more hindrances to copyright and authorship for AI under US copyright laws. Presuming that the nature of work produced by ChatGPT is derivative, in the US, creation of derivative work cannot take place without the consent of the owner of the original work. This explains the recent decision of the US Copyright Office, wherein it had terminated the registration of a copyright in a graphic novel which was produced substantially with the help of an AI tool called Midjourney. So that's about it about the laws both in India and abroad around copyright, which may affect ChatGPT. Now, as I explained, ChatGPT does not possess intellect. It cannot claim copyright over content as per the court judgments in India. However, it is very much possible that in the near future, ChatGPT or other forms of AI could evolve to such an extent that they would actually have a mind of their own or intellect. And the IP regime in India and worldwide does not yet lay down IP rights for AI. So I believe necessary amendments should be incorporated in this regard that pertain to IP or intellectual property. And once such amendments are incorporated, the next issue to be tackled would be with respect to ChatGPT, would be the ownership of copyright in the content generated by it. So I recommend that ChatGPT should then incorporate a feature which verifies that the content generated by it is new and copyrightable, even if it is a derivative work. And OpenAI should be held liable in the event that ChatGPT wrongly verifies blatantly copied material as a valid derivative copyrightable work. So that's about it as far as my recommendations go, and I hope you got some valuable insights from this episode. I would love to hear your questions and get your feedback in the comment section of this post. Please stay tuned for more episodes with exciting new developments in the IP and tech law space. See you soon.